Hello everyone. Today we will discuss about doctrine of judicial review. So first, let us understand what is meant by a judicial review is. In general, we know that the three organs of the government is legislature, executive and judiciary. So any government generally will runs on three organs. So generally we will follow the principles of checks and balances because no organ has domination on other two organs. So always the Indian constitution respects and give provisions to have checks and balances over other. So we know that the three organs of any state is a legislature, executive, judiciary. Now in this context we will see what is the role of the judiciary and what is meant by a judicial review is. In general, the judicial review refers to, as the name indicates, it is just a review, which means that the power of the judiciary to review laws and also executive actions to ensure they are in conformity with the constitutional values. If any law or action violates the constitution, the judiciary has the power to declare such laws as null and void. And if we can see the constitutional structure, on what basis the judiciary is getting this power, the first and foremost you can remember is Article 13 of the Indian Constitution. The Article 13 of the Indian Constitution says that any law which is inconsistent with or in derogation of the fundamental rights is void. So any law which is in void with the which is against to the fundamental right is void. So the judiciary uses and quotes this article frequently to declare some laws are inconsistent. The important other article was Article 32 and 226. These two articles empowers the Supreme Court and High Courts. Article 32 empowers the Supreme Court and Article 226 empowers the High Court to issue writs for the enforcement of the fundamental rights. So these two articles, and another article is Article 141. So the law declared by the Supreme Court is binding on all courts. So these three are the basic constitutional basis for the judicial review. So whenever the question is asked in the examination, especially in the mains examination, you have to quote these three articles. Now let us see what is the scope of the judicial review. If you can see the scope of the judicial review, it will cover legislative actions, which means that the laws passed by the parliament or state legislatures, if they are against to the principles of the constitution, the judiciary has power to strike it off. The second one is executive actions. Executive actions. So actions and decisions of the government and the authorities of the government taken by the people. So if they are also against to the fundamental rights, those also can be considered and will be declared by the null and void by the respective high courts and Supreme Court. The third one is administrative actions, which means that the actions by the authorities like tribunals, commissions, etc. The fourth one is the constitutional amendments. Constitutional amendments, which means that to check if they violate the basic structure doctrine. We know that the basic structure doctrine was already mentioned in the Kesavananda Bharati case. So if any amendment is against, if it is violating the basic structure doctrine, obviously those also can come under judicial review and the courts has respective right to declare those laws as null and void. And if you can see the landmark judgments to quote in your exam, just we will see only the landmark judgments. The first one is the Kesavananda Bharati case. Kesavananda Bharati case, which is in 1973. Through this case, actually this is the case against the Kesavananda Bharati versus State of Kerala in 1973. It introduced the basic structure doctrine, so which means that the parliament cannot alter the basic structure of the constitution. The second landmark judgment is Minerva Mills versus Union of India in 1980. It strengthened the balance between the fundamental rights and the directive principles. The third one is L. Chandrakumar versus Union of India 1997. According to this, it held that judicial review is part of the basic structure of the constitution. Right? So we know that by quoting the law, it is against to the basic structure of the constitution, the courts has a right. In L. Chandrakumar versus Union of India, the court says that this judicial review itself is the basic structure of the constitution. And fourth important one is Golaknath versus State of Punjab. Golaknath versus State of Punjab, it is in 1967. According to this case, the parliament cannot take away fundamental rights through amendments, which means that, of course, later partly it was overruled, but it clearly says that it cannot take away the fundamental rights through the amendments. And even though if you can do that amendments are to be within the scope of the judicial review. That's what we have to understand. And if you can see the very recent cases, because those are very much important for the exam, so we can see that where the judicial review came into the picture. The first one is the same-sex marriage case. Same-sex marriage case, that is the Supreo versus Union of India 2023. So the context for this case was the petitioners sought legal recognition of same-sex marriage under various personal laws. But according to the judicial review, the Supreme Court upheld the constitutionality of the existing laws not recognizing the same-sex marriages. Even though it is against to the same-sex marriage advocates, but still the Supreme Court clearly says that it upheld the constitutionality of the existing laws, where the existing laws are not recognizing the same-sex marriages. So the court ruled that it cannot make a law, it only reviews its constitutionality, which means that the judiciary maintains restraint, not overreach here. So in this type of cases, the judiciary can use its review power to define or to validate any constitutional laws. The second one is abrogation of Article 370. Abrogation of Article 370. In this also, the context is multiple petitions challenged the constitutional validity of abrogating Article 370 that gives special status to the Jammu and Kashmir. But the Supreme Court upheld the validity of the Presidential Order and Reorganization Act, stating that the procedure was constitutional. We know that after the abrogation of Article 370, several petitions challenged this constitutional validity and the process how they abrogated this Article 370. But Supreme Court says that it is valid, and the Presidential Order and also the State Reorganization Act is according to the constitutional procedure. So it affirmed Parliament's power under Article 356, read with Article 370, the critical use of judicial review in a constitutional political matters. The third one, you can see the electoral bond scheme. Electoral bond scheme. If you can write, if you want to write it in a more, what we can say, in a formal language, Association of Democratic Reforms versus Union of India. In this case, the electoral bonds were challenged for violating the transparency and free and fair elections. So the judicial, by using the judicial review, the Supreme Court struck down the scheme in 2024, and it also states that this particular scheme is violative of Article 19(1)(a), that is freedom of information and expression. In this case, the significance part was the Supreme Court reaffirmed the opaque political funding undermines the democracy, which means that the strong use of judicial review for upholding fundamental rights. If you can see that, maybe in this case, the judiciary supported the government of the day, but in this case the judiciary is against to the decision taken by the government of the day. So which means that the judiciary is largely, it is neutral and it is not taking the stand of one particular person. It will concentrate only on the principles of the constitution. And the fourth one, important one, you can see Delhi Ordinance case. Delhi Ordinance case. Here the context was the central government passed an ordinance limiting powers of the Delhi government regarding administrative services, right? According to the Supreme Court, it struck down the ordinance and affirming the elected government's primacy in administrative control. So whatever the ordinance passed by the central government, which is limiting the powers of the Delhi government, was struck down by the judiciary. Even this is also against a blow to the government of the day. So which means that again the judiciary is not going to the it is not going, or it is not submissive to the government of the day. It will only see the merits of the case. So in this case also it clearly signifies that it reaffirmed federalism. The Supreme Court gave lot of importance to federalism and democratic accountability, and that is a critical review of the center's actions actually. And fifth important case you can use to write an exam is Supreme Court on EWS reservations. So the context here is that 10% reservation for economically weaker sections was provided under Article 103 Constitutional Amendment. So the several petitions again were filed in the Supreme Court. So that again the Supreme Court went through its judicial review power. And initially it was upheld in 2022, but still a review petition was filed in 2024, and that petition was also dismissed, reaffirming that it does not violate the basic structure. So the providing reservations, the 10% reservation to the EWS classes is not against to the constitutional values. It also signifies and it also clarifies the scope of judicial review over constitutional amendments vis-a-vis with basic structure doctrine. The sixth one you can quote in exam is right to privacy and Pegasus spyware allegations. Right? Here the context is allegations of the state surveillance using the Pegasus software. So the government is using Pegasus software and it is increasing surveillance on its citizens. But the Supreme Court immediately, when the petitions was approached to the Supreme Court, it is against to the right to privacy, because we know that the right to privacy is a fundamental right declared by the Supreme Court itself. It appointed a technical committee, and also it found that there is no conclusive evidence but emphasized the importance of the privacy under Article 21. So whenever the petitions was raised about the privacy, even though it is against to the central government, still the Supreme Court appointed a technical committee. So which clearly says that Supreme Court has power to review such kind of the decisions. So the judicial review of executive surveillance practices upholding the citizens' fundamental rights. So by violating fundamental rights, the state cannot act like a surveillance state, right? The another one, even though it is not relevant to the examination, but still you can remember the ban on BBC documentary. Here, the BBC initially created a documentary which is critical of the current Prime Minister Narendra Modi, and citing the reason of public order. Immediately the petitions were challenged against the government in the Supreme Court because it is a freedom of speech and expression. The Supreme Court refused interim relief but heard arguments on freedom of expression of speech. The outcome is very clear. It set the stage for the review powers under IT rules. And also, the judicial review clearly says that the ban on the documentary was valid, and it is clearly stating that the reason of the public order will apply in these principles. So the ongoing judicial review on free speech versus state regulation of the content will also apply in this case. So these cases actually will reflect how judicial review in India act as a guardian of the constitution, especially in upholding the fundamental rights. So we can see that it will uphold fundamental rights. And the second one is it maintains the federal balance, and also it will check legislative or executive overreach. Executive overreach. And the fourth one is preserving democratic values. Preserving democratic values. Right, so we need to actually understand what is a judicial review, what is a judicial activism, what is a judicial overreach, because that is a very common question. So sometimes the judiciary is going beyond its perspective. So right now, just now we have seen that judicial review means it is the constitutional duty of the constitutional courts to invalidate unconstitutional acts. But what is meant by judicial activism? Just we will see the basic introduction, because you need to understand. The judicial activism means the proactive role by the judiciary to enforce rights and also address the public interest. Now, up to this level, it is fine. There is another term called judicial overreach. Judicial overreach, which means that the judiciary crosses into the domain of the legislature or crosses into the domains of the executive. Then that is called as judicial overreach. Now, just now you heard about the judicial review, right? Now you can think about judicial activism and judicial overreach and identify some 4 to 5 cases in the judicial activism and also 4 to 5 cases in the judicial overreach, because tomorrow the question may comes that did the Indian judiciary is really going under the in the domain of the judicial overreach, or do you accept the judicial overreach is existing in India? Such type of questions may come in mains or interview. So you have to you have to read about judicial activism and judicial overreach also, along with the doctrine of judicial review. Thank you so much. We will see some other important concept in the next video.